Thank you, everyone, for joining us this afternoon. I am Attorney Wilda Pomales. I'm the family law attorney here at our firm, the Legacy Legal Team. Today, I will be talking about relocation. I've had a couple of consultations now asking me what the process would be if they wanted to relocate. And so there are a couple of questions you have to answer before you can even get into that. And it will depend on if there is a already an order in place for paternity, like if you went through a petition to establish paternity or a divorce, and then there was a time sharing schedule. So if there's already a parenting plan in place, you already had a case in court or a case is pending, someone filed a case and you want to relocate, then you have to follow Florida Statute 61.13.001. Follow those steps. If there's no case pending, if there is no final judgment for a divorce or paternity case, there's no parenting plan in place, then you don't have to follow the statute. And as the mom, if you're with the children, you can relocate, you can move more than 50 miles. And so today, particularly, we'll be discussing whether you can relocate if there's a pending case. So these are just for matters that there's something pending in court, whether it be a divorce or a petition to establish paternity, or something already was ordered and entered and some time has passed, and now you're trying to move more than 50 miles from where your address is at currently. And so there are a couple of steps you have to take. So the first is, okay, we have a pending case. Do you have an agreement? And so do you and the other parent have an agreement that it's okay for the move, for you to move with the child? And so if there is an agreement, it's fairly easy. You just have to draft a long distance parenting plan. The move has to be a permanent move, right? More than 60 days. And so if you're looking to move more than 50 miles from where you're currently living and it's more than 60 days, so it's not a vacation, nothing that's temporary, that's when you would have to go through this. So if you have an agreement, just make sure you get it in writing. You put in the new time sharing schedule, what that communication will be with the parent that is not moving, the non moving parent with the child, what the exchanges are looking like, the transportation, if it's a flight that needs to be scheduled, who will be flying to pick up the child, who will be flying to return the child, if the child is under the age of flying on their own. Will there be a parent or a family member that will be flying with the child, or will that be allowed, or will the child be allowed to maybe fly with assistance from the airline, getting one of the crew members to take care of the child while that flight is happening? Those things need to be put in there and filed with the court in that pending case or the case that already has been closed, but you want to file this new parenting plan. So that's an agreement. Very easy, straightforward. We just need to make sure that those terms are included in that new parenting plan because now it'll be a long distance parenting plan. So what happens in the case of the parents not agreeing? And so one parent wants to move with the child and the other parent does not agree. There is a process you have to go through the court system. And again, a reminder, there is a pending case in this situation, in this scenario, or there was already an order entered. There's no pending case. You do not have to worry about this. You want to move, you've spoken to the other parents, and the other parent is not allowing you to move without court intervention. You have to file a petition for relocation. And so, again, the statute is Florida Statute 61.13.001. And that gives you the guidelines and it lays out what exactly needs to be included in that petition for relocation. And you have to be very specific and follow that statute. It is always recommended that you seek counsel because it is so specific and you're not doing it correctly, it can get dismissed. You don't get to the court system. And so if you move, you don't want to be found in contempt. So make sure you seek legal counsel. We're here if you want to schedule a consultation just to review what needs to be done, or if you want us to be drafting the documents. But once you file that petition, certain things that you need to include in there, right? The reason why you're seeking the relocation, some of the things that you need to include, the proposed new parenting plan, what that new timeshare schedule may be, the address of where you're going to be moving to, if you already have that information. If this is for work purposes, a lot of times parents get a promotion or opportunities that are outside of the state or more than their 50 miles from their current location. And so if this is for employment purposes, you will need to include that job offer letter to that petition. And so the other party that's not, the parent that's not moving, will have to be served. So you have to serve the petition, make sure they're aware. The other party will have 20 days to respond with an objection as to why they are not allowing that. And their objection really does not have to be as specific, if you could say, or as detailed as the petition. As long as there's an objection, the court will have to have a hearing, an evidentiary hearing as to what's in the best interest of the child or the children. And so you will have to go through a hearing. Now, because it is one of those things that sometimes there is a time limit on the employment opportunity that the parent may have, the court does have 30 days to be able to give you a hearing date to be able to be heard. And so that way the parties can go and find out, and maybe on a temporary basis, the relocation can be granted. It does not necessarily mean that it will be granted in the final hearing, a final judgment, but we can go to court on a temporary basis and find out if the court will allow you to move while you continue with the case, whether it be a divorce or a paternity case or a modification of time sharing, right? So if you've already had that final judgment and you're trying to modify, also do that relocation petition to relocate. Just in case that petition to relocate gets denied, you have that supplemental petition to modify. And so that way, one or the other, you're going through that process of reopening the case and going to a final hearing, a trial to be able to determine whether you can have a permanent move or not. And a lot of times people or parents come and say, I'm moving, I'm getting a better job, my child has to come with me, and it's going to be better for them because of my job opportunity. And that's not always the case. You have to be very careful, always keeping the children's best interest at the front of everything. And so the court is going to determine whether it is in the children's best interest, not in your best interest, not in the other parent's best interest. And so a lot of times it's not just whether you're getting a better job opportunity or not. There are things that you need to look into and have ready for the court to be able to hear testimony on this. Certain things like the school district is the child with special needs child, and maybe there is better opportunities of programs, therapy sessions in a different state, different area. And so you need to have all that data, all that research completed so that, and preferably if you already have consultations with doctors, teachers, maybe they can testify at your hearing or the temporary hearing or the final hearing so that the judge can have all that information, because simple fact that the party is, or one of the parents is getting a better job does not give them that automatic green light to be able to move. That might not be in the best interest of the children or the child. Other factors to consider is that relationship with the non-moving parents, right? Do they have continuous relationship and timeshare with that other parent that now they're not going to have? And so if you're sharing week on, week off with the other parent, or you're pretty much at a 50-50 timeshare schedule with the other parent, now that move is going to take place, what is going to be that time sharing with the other parents? And are they going to lose out on that relationship with that parent? So what will happen to foster that relationship? And are there other siblings, maybe half siblings, step siblings, other relatives maybe that are part of their circle, grandparents, aunts and uncles? And so you have to bring all that information into that hearing to be able to show the court how it's in the child's best interest. Things to consider: schooling, doctors, programs that they may be needing, the class sizes, right? Are we going into from an A school to now moving into a B or a C school, and all that needs to be discussed and presented in front of the judge so that there's an actual order. Now, just because you get your temporary relocation granted, it does not mean you will get it at the final judgment, and vice versa. Just because you get it denied at that first initial hearing for temporary move does not mean you will get it denied at that final judgment, at that trial session. So don't get discouraged. Just make sure that you are including as much information, going with what that statute states, to include in that petition, doing it exactly how it's required, per the statute, and then just bringing all the information into that hearing if there is no agreement. Certain things that also affect is the cost of now the traveling. Will the child be traveling more? Will the cost be a burden to the non-moving parents? Are the resources, financial resources of both parties at an equal footing per se? And so if it's going to hinder the other party, the other parent's relationship, they won't be able to make those travels, and it's going to be harder for them to continue with their time sharing, then that's definitely something that the court's going to have to consider. Because at the end of the day, you have to remember that the child needs both parents, right? And the court is always going to see what's in the best interest of the child, which is having both parents there. And so if one parent is trying to move just to keep the other parent from exercising equal time sharing, there's that good faith versus bad faith attempt of why that move is happening. And so you have to make sure that you have all your information. Now, the other things that can affect it is the child's age. Sometimes the kids are older and they're able to voice their opinions to the parents, right? Not necessarily to the courts, but to the parents. And sometimes it's easier for the younger children to be, we'll say, bribed in the sense that, hey, one parent may be saying, we're going to have fun, we're going to be moving. And so that's why the court does not get involved with the children testifying as to if they prefer to move or not. Sometimes that's not in the best interest of the children. That is not always an easy case. Some parents are letting us know, my child wants to move, my child is excited, but that could be just because they think they're going on a trip, on vacation. That's always exciting, right? And there are specific elements that the court will consider in determining whether it's in their best interest or not. Let me just see, based off of the statute, about forgetting anything else. The petition, if the court has not determined, it's not a matter of just filing the petition for relocation and then you moving and then waiting for there to be a hearing. If you move before the court actually enters either a temporary or a final order, then you can be found in contempt. The court can order you to move back with the child or send the child back to that non-moving parent. And it's very careful not to move against the court's order or against the other parent's desire or their objection to the move. As I mentioned before, some parents are trying to move just so that the time sharing won't occur. And so the court will look at that. If you are the parent that's trying to move and there's also evidence to show that you have not been trying to foster the relationship between the non-moving parents, and the court may see that as it being more difficult if you were to move with the child. And so there's going to be evidence to show what that relationship is, that co-parenting relationship is between the parents in determining whether it is in the best interest of the child. So you always have, in every case, you always have a duty to continue to inform the court of your current information, whether you move, even if it's less than the 50 miles, you always have to be informing the court. But specifically, if you're seeking to move more than the 50 miles, you need to always make sure to let the court know exactly what that new address will be as soon as it is known to you. Or if it changes, make sure you're informing the court of the new address, because that goes to show of your attempt to communicate with the other parent and have that good co-parenting relationship. Some things that also come into effect. Some parents come in and say the other parent never really had a relationship with the child, or they're not even exercising the time that they do have, that the court has ordered currently. So that's all information that can be brought up at that hearing to make sure that you are meeting your burden, whether it's in the best interest of the child. And if you've met your burden and the court does find that it may be in the best interest of the child, then that burden shifts over to the other side to show that the relocation is not in the best interest. And so that's all that is. It's pretty much essentially a mini trial before your full trial when you're going for temporary relief. So if, again, you file that petition, the court is going to have to give you a hearing within the 30 days. A lot of times for regular hearings and other matters, the court takes a little bit longer to give us some hearing time, and it'll depend on the judge's availability. But in this particular case, and these petitions to relocate, the court has to give you that time within 30 days. And it is, if you're self-represented, it is up to you to be reaching out to the judicial assistant, finding out, hey, when can I get my hearing date so that you are not found in contempt? Because sometimes those job opportunities, again, have a deadline. And if you move prior to your order, you can't be found in contempt. Other questions that may come up is who will be responsible for the expenses of having to travel back and forth. So if the child needs to travel either airfare or car transportation, if you guys are meeting in the middle, it shows that there's a good faith effort from the moving parent to say, I may be able to split the cost 50-50. It doesn't have to be all on the non-moving parents. So that could also be something that is suggested in the petition, that any cost for transportation may be split 50-50 or covered by the moving parent sometimes. For example, some parents have benefits through airlines, and so it doesn't cost them anything to fly the child back and forth. And so they may be able to extend that benefit over to the non-moving parent. And so that's a possibility. It's all a matter of getting creative to make it as a smooth of a transition as possible for the children or the child, so that relationship is not lost with the non-moving parent. So let me see if I have any questions here. I do not think we have questions, but if, again, anything comes up, any questions as to what needs to be done, how the petition needs to be filed, what needs to be included in that petition, definitely give us a call, schedule a consultation. Do not go at this on your own, because you can lose time by filing incorrectly. The court may deny it automatically, requiring you to refile. And so if it's something that needs to be done sooner rather than later, if you don't have time, then you definitely should seek counsel as soon as possible. The other thing is future moves. Sometimes people are anticipating that they're going to move or they want to move. And so they're saying, oh, in a year from now, I would like to live in Miami versus living in Orlando or in the Claremont area. Okay, a year from now, you will have to apply for that or file that petition for relocation. You cannot seek a final order or a temporary order from the court if it's something that you're planning on doing in the future and it's not certain. The court can only look at what's in the best interest of the child today. What is the current situation of the family? And so you can't ask the court to let you travel when the child is older or in the future, because the court cannot determine what's in the best interest of the child in the future, right? We are not psychics. And so you need to make sure that if it's a move, it's a job offer that was offered now for something that you need to move relatively soon. And so you can't ask the court for potentials or different scenarios if you're not sure of what that move is. And so we have a question here. How does that work for out-of-state time sharing, or is that based on each state? And so this is based on a Florida case, right? Florida having the jurisdiction over the children. And so that time sharing is going to be based off of Florida jurisdiction for the child. And so right now, the presumption is that the parents start off at 50-50, but being that now you might be more than 50 miles away from each other, because again, the relocation is more than 50 miles. So that 50-50 may not be feasible for the parties. And so what are the parties going to come up with? They can come up with any type of time sharing that they want, or the court is going to have to determine maybe summers for the non-moving party while the child is during the school year with the other parent. So it just depends on the family situation, the age of the children. If you're school age, then you're going to have to be subject to the school calendars of that state. And if you're in a different state, the holidays are different, the time off is different. But if they're not school age, then we can get creative. The court can say 1 month on, 1 month off for the parents until the child becomes of school age. It just depends on the situation of parties. Okay, there's another question. If I need to move, can the court approve if my child's father doesn't? Yes, the court will, again, just look at the best interest of the children and determine if that is in the child's best interest. And sometimes what happens is that you may have a better schooling in a different state. You may have a better support system. So if the non-moving parent is not involved in the child's life and you don't have anybody else to be helping you with the child as far as care and involvement, and you have family that can assist you, you have a support system that can assist you elsewhere, then that may be in the child's best interest, right? Being surrounded by family that can assist instead of having to be in daycares. And so the court may determine that it's in the best interest and allow you to move, even if that other non-moving parent does not allow you or objects to it. So the court will have to go through all those elements. Again, there are 20 factors when it comes down to best interest of the child. And looking at those factors and seeing how that move will affect the child is what the court essentially has to go through. That's why it's very important that you find out and do your research before actually moving and filing the petition. Find out what's that school district like, if they're school age, what's your support system over there, what's the neighborhood like, are we in A schools, B schools compared to over here? And you want to bring that in front of the judge because of those factors that need to determine. Again, if you have any questions, feel free, definitely give us a call back. I don't think we have any other questions here, but those are, again, not just because you have a better job, is it always in the best interest of the child to move. There have been situations where that was the only reason the parent wanted to move, was because they had a better opportunity somewhere else, but it didn't take into consideration that now the child is not going to be with the other parent half of the time, or they're leaving their school system behind, or they're leaving their cousins, their family members, grandparents behind. So just because it's a monetary gain for one parent does not mean it's a best interest for the child. So you need to keep that in mind. Definitely give us a call. Any questions, we're here to assist and we're happy to help.